Thank you for WITA and Bruce. It's good to be back active in WITA activities. And I want to congratulate or thank Kira for the hard work. And any criticisms I may make of the agreement, USTR, the administration, are not personalized. But we do have some concerns and problems about ACTA. But let me set the stage too a little bit. I represent a broad range of computer, telecom, internet, various high-tech companies. Almost every one of my companies requires and depends on greatly intellectual property. But we've also have a deep understanding that the genius of the United States intellectual property system is its balance. It has strong rules, but they are balanced. There are limits, there are purposes that are clearly defined for the various categories of intellectual property. And they are different. The purposes for trademark, for copyright, for patents are different. Their amount of exclusivity, the amount of rights they grant, the terms for those rights are all different. The importance to society underlies U.S. intellectual property rights. So they are in fact a right which is not in the U.S., and some countries have a different view, are not an inherent natural right, like your right to liberty that we enshrine. It is a right designed to in fact benefit society by giving incentives and certain benefits and encouragement to do innovation in a certain way. In order to create that set of rights, we do take away some other rights. We take away, from the free marketplace, a certain amount of competition. And we take away from our ability to speak and talk and communicate limitations when we use copyright as the biggest example, but it applies to all of them. So we are in fact limiting certain parts and other values which we have in order to create intellectual property rights. We think that is good as long as we understand that there is a cost-benefit process here to look at in dealing with the underlying value of intellectual property. This is important because when we go into the international arena to negotiate in this area, one, to keep in mind the differential character of the different types of IPs, but also to understand that the enforcement aspect to deal with all these varied areas is very tricky to do in an omnibus trade agreement, kind of one more or less with some notations of differentiation, one overall IP protection. I mean, a trademark, a patent, and a copyright can be extremely different, deal with different industries, different players, different dynamics. I guess underline and say copyright, patents, trademark, they're all important, but you can have too much of a good thing. I think Emory, I think lots of people, a broad consensus agree that the patent law system is in need of great reform. Legislation has been pending and has come close to passage. The truth is, even though it's not yet passing, almost everybody agrees we need reform, we just disagree on how. But the patent system is a good example of how intellectual property, particularly in a modern era and the internet era, has come to mean in its impact on real world players something different than it meant years ago when most of copyright was created. It dealt with authors and artists, not, and Emory made a great point, of software, which is now a building block of society. And whether rules that were developed in that setting still apply is important. The reason I say this is because intellectual property, the substantive law, which we're now saying we're going to enforce rigorously, is in flux. In many key areas, then what is an infringement is up for grabs. There have been, I believe, 7 Supreme Court cases on patent. The Supreme Court itself had to involve themselves numerous times because patent law had become too complicated and had gone off in weird directions. We have seen examples, and I'm not going to give the horror stories of some silly patents that have been granted, of copyright lawsuits that have made little sense. And so when we're saying, let's go enforce this, it's not like we're saying bribery laws, okay? We know what bribery is, maybe we can debate it and maybe on the edges, but fundamentally we know, so let's get the world to agree on anti-bribery. Infringement is in fact, and Emory likes to use piracy and theft in instances that may make sense, particularly in the true counterfeiting context. But a lot of issues here are really not that different than contractual disputes. When we have disputes between major players over carriage of content, and subjecting them to certain kinds of enforcement as if they were all theft is in fact risky. So you can have too much of a good thing in the IP world. Our copyright laws are in flux, and it historically is worth a look. Player pianos, photocopiers, VCRs, M3 players, TiVos, these were all reviled as pirates. Today, yeah, pioneers, great assets to our economic growth and technology. Cablevision, company very much in the news right now because they're in a slugfest with Fox. Okay, they had a fight not so long ago with big content. It had to do with whether or not they could provide TiVo-like functionality. They were accused of being commercial pirates. Went to the Supreme Court. Now they are understood to be pioneers. They were accused of being industrial scale pirates. That was what was being thrown at them. So when there's this uncertainty in law, we want to be very careful that what the norms we export are not building in inflexibilities to deal with, in fact, very important changing substantive law that could impact greatly who is and who is not covered by various enforcement provisions. There are usually two types, stepping back now, in process and substance. There are two criticisms of ACTA, it's been mentioned, process and substance. They are intertwined. Process, I'll go through quickly, which is ACTA was not really negotiated in a more democratic form. WIPO does exist, the World Intellectual Property Organization. It was there, could have been as an adjunct into that space. They were really cut out of this. The transparency was a big issue. And you could say there was a bait and switch, anti-counterfeiting. And it really was originally focused, and whether it was known by everybody or not, to be maybe more than that. In fact, it sounds like it was just on trademarks and counterfeiting and the exploding battery. I mean, the amount of consensus you can have about those kind of issues is huge. It is when it expanded beyond the concept of anti-counterfeiting into various aspects of internet liability that tremendous pushback and controversy got involved, because a lot of those constituency looking at an anti-counterfeiting agreement said it doesn't affect us. So nobody reached out to pull them in and negotiate.